Hey guys, so today we're going to be talking about employment discrimination. So, the laws and administrative agencies that we have today to protect employees and applicants against discrimination in the workplace stem from the civil rights movement. Title VII of the Civil Rights Act of 1964 prohibits discrimination against employees, applicants, and union members on the basis of race, color, national origin, religion, and gender. More recently, though, the Act has been amended to include and protect employees on the basis of age, military veteran status, pregnancy, disability, and sexual orientation. Now, one of these administrative agencies is the EEOC, which stands for the Equal Employment Opportunity Commission. Now, they investigate claims of workplace discrimination, and they do get a lot of claims. So, they say that they only investigate priority claims or priority cases of discrimination, so cases that aren't immediately investigated by them. They request more documents and they collect statements to get more information. But in this presentation, we will primarily focus on discrimination in the workplace on the basis of race and religion. So the first step in the process is to file a charge of discrimination with the EEOC within 180 days of the last act of discrimination. From there, the EEOC will determine whether there has been some form of discrimination, and if they decide that there was, they would issue a right to sue letter. This is basically just the plaintiff's ticket into federal court. So, to establish a discriminatory act in the court of law, the plaintiff must prove the claim through a prima facie case. So there are 4 steps to doing that. The first is to show that the plaintiff is a member of a protected class. Now, a protected class just means an individual who is of a certain race, gender, nationality, or sexual orientation, just to name a few. So that's what class means, protected class, that is. Now the second one is to show that the plaintiff applied for and was qualified for the job in question. The third is to show that the plaintiff was rejected by the employer. And lastly, that the employer filled the position with someone outside the protected class of the plaintiff. A more detailed definition of protected class is provided by the EEOC's website. They say applicants, employees, and former employees are protected from employment discrimination based on race, color, religion, sex, including pregnancy, sexual orientation, or gender identity, national origin, age, 40 or older, disability, and genetic information, including family medical history. Quick side note, it is legal for employers to discriminate on the basis of age if the applicant is 40 years or older.
In this case specifically, the main focus is religious discrimination. Benjamin Andres filed a complaint that his employer, the Indiana State Police Department, discriminated against him on the basis of religion in violation of Title VII of the Civil Rights Act of 1964. In his complaint, Andres stated that Indiana hired him as a certified Indiana State Trooper and that he was later notified by the Indiana Police Department that he had been assigned as a gaming commission agent to the Blue Chip Casino in Michigan City, Indiana. Andres stated that he is a member of the Community Baptist Church in South Bend, Indiana, which is a religion that believes gambling is a vice which is contrary to the principles of the Bible, and that its members should not gamble in any way at all. He claimed that he informed his employer of his religious convictions and beliefs that would prevent him from accepting the assignment as a gaming commission agent. He then requested an alternative assignment, which Indiana refused to accommodate. Indiana charged him with refusal to comply with a written order and insubordination and terminated his employment. He claimed that Indiana's acts were performed with malice, intentional indifference, and reckless indifference to the civil rights. The legal issue in this case is whether or not the Indiana State Troopers' actions constitute discrimination under Title VII and its progeny. The answer to that is yes. Discrimination was in fact present in this situation. Religion includes all aspects of religious observance and practice as well as belief, unless an employer demonstrates that he is unable to reasonably accommodate an employee's or prospective employee's religious observance or practice without undue hardship on the conduct of the employer's business. In this case, general principles of law apply. Title VII of the Civil Rights Act specifically says, "It shall be an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin." It also states that it is unlawful to limit, segregate, or classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. Andreas received unequal treatment by the Indiana State Police because he claimed that he could not work in the casino due to his religious beliefs and was ultimately fired from his job for them as proven with evidence of letters between the parties. Disparate treatment was in play. Andreas's religious beliefs and practices made it so that in this case he is part of a protected class. The Constitution protects his freedom of religion, which prevents his employer from being allowed to discriminate against him for this reason. Terms and conditions of employment also apply in this case because Andreas's religious practices prevent him from taking part in any work involving casino or gambling. Therefore, this type of job and location that the police department assigned to Andreas was unreasonable. So for this case, defenses, exceptions, policies, and actions that could have been done or applied to this case include the following. The first is bona fide occupational qualification, which only applies to cases where discrimination is intentional. It is involved when the protected class of gender, religion, age, national origin, or color is essential to a job. For clarification, this does not include race. This is an employment qualification that employers are allowed to consider while making decisions about hiring and retention of employees. The qualification should relate to an essential job duty and is considered necessary for operation of the particular business. Another would be business necessity, which is where a business requirement resulted in unequal impact that is necessary to the job, unless there is a pretext that offers explanation and reasoning. The next is undue hardship, which is an accommodating action that places significant difficulty or expense on the employer. Employers are required to provide reasonable accommodation to qualified individuals with conflicting religious beliefs and/or disabilities. But when an accommodation becomes too taxing on the organization, it is classified as an undue hardship and is no longer required. The next is the affirmative action policy. Affirmative action policy is a policy in which an individual's color, race, sex, religion, or national origin are taken into account to increase opportunities provided to an underrepresented part of society. If temporary, it is remedial and not an absolute bar. Lastly is prompt remedial action. It is defined as conduct reasonably calculated to prevent further harassment. It is when the employer immediately changes and rectifies the problem once called to their attention. And now for the legal conclusion. The Court of Appeals took the position that Andreas's assertion in his initial complaint that his discharge constituted a violation of the United States Constitution and Indiana Constitution, each guaranteeing religious freedom and free exercise thereof, was sufficient for Andreas to preserve the constitutional issue for review on appeal. Therefore, there was unequal treatment of a protected class as to terms and conditions of employment with no valid defense or exception. In discrimination cases, possible remedies for plaintiff employees who suffered discrimination may receive reinstatement, seniority, retroactive promotions, back pay, affirmative action policies, damages with caps on amounts, compensatory action if the discrimination was intentional, punitive action if malice or reckless indifference only for private cases, and damages limits of $300,000 if the company or business has greater than 500 employees, and a limit of $50,000 if there are less than 100 employees. If there is evidence of employee misconduct, however, after the event, the victim's misconduct may limit damages, but they do not fully excuse the discriminatory act.
Now, the short-term actions in the case that we talked about, a recommendation would be to reinstate the employee that was wrongly discriminated against and receive back pay as well for the time that they missed. This would give the employee economic relief as well as an understanding that his or her department realized they mistreated their worker and were in the midst of fixing the inner workings of the company that were flawed. Now, a long-term remedy to show the care and understanding of the company as a whole would be to acknowledge the meaningful days and holidays of that certain employee's religion and allow time off for those who practice. Another would be to instate a diversity and discrimination seminar where employees would have to attend and gain an understanding of different cultures, points of views, and that would hopefully allow for a safe and educated workplace, emphasizing that the goal is to understand and accept the beliefs of others rather than ostracizing them. So there are more basic remedies and solutions, such as the Title VII compensation of $250,000, the Title VII front pay, which would pay for the past position's salary if that position is no longer available, the attorney fees. The plaintiff can punish the company for their wrongdoings with punitive charges. And then there's also more solutions to the workplace that are more basic, such as recruiting from a more diverse environment, which would diversify the workplace, and always be looking for something as to why it could be considered offensive or discriminative rather than why not. In terms of the actions a business should do short term, on a more broad point of view, would be something like an apology or announcement to the public and their employees. This actually happened to Netflix this year, as they were silent during the Black Lives Matter movement was rocketing into the eyes of the media and the public. And after they were being silent, they sent out a public apology to the inner workings of their company and built programs to help with the problems their employees were facing, such as mandatory breakout rooms and departments, which allowed the employees to actually express themselves. And things like this can be constructed and conducted in a very short amount of time and are super easy for a company to do. So, as mentioned before, seminars are a great way for a company to become informed and educated on the topics of discrimination, yet there are other, some might say more meaningful ways, such as company retreats, a self-help center at the workspace, and many other companies are creating their own ways, such as Netflix creating a safe space for their employees. Each employer should do what is best for them based on their specific size and focus. And another aspect that is often forgotten about is the hiring process. Employers should ensure that they're reviewing their hiring staff and their evaluation process as well constantly. This is to accommodate for all applicants and not letting their religion or ethnicity get in the way of if they're hired or not.